Good evening, everybody. My name is Jim Anaya. I'm the Dean of the University of Colorado Law School. It's my pleasure to welcome all of you, students, friends, and members of the legal community, including, of course, our speakers tonight, the Honorable Judge Carlos F. Lucero, as well as, and I believe he's here, another 10th Circuit Court of Appeals Justice, the Honorable Timothy Timkovich. There he is. Welcome, Judge Timkovich, and I think there are other judges in the room, but I'll refrain from trying to call out a few because I'll miss, no doubt miss a couple. But anyway, welcome to you all. Tonight's lecture is presented by the law school's Byron White Center for the Study of American Constitutional Law, and co-sponsored by Colorado LGBT and the Colorado Hispanic Bar Association. We're very pleased to be able to co-sponsor this event with them. The Byron White Center is our premier center of learning, or one of our premier centers of learning, scholarly inquiry, and public service. The center honors the late U.S. Supreme Court Justice Byron White, a Coloradan who made a mark on the country's legal landscape by addressing many of the prominent constitutional issues of his day. True to Justice White's legacy, the work of the center is premised on the belief that informed and engaged citizens are essential to our constitutional democracy. Through its varied programs, the center has become a hub for engaging law students, lawyers, judges, and interested citizens, including local high school students and teachers, in the constitutional conversation. The center's John Paul Stevens Lecture, named for another prominent member of the United States Supreme Court, or former member, brings to the campus each year distinguished jurists to contribute to the life of our community. This year's jurist is the Honorable Carlos F. Lucero of the United States Court of Appeals for the 10th Circuit. Judge Lucero is a native Coloradan from the town of Antoñito in the San Luis Valley, close to Colorado's southern border with New Mexico, where I am from. So I'm glad to have almost someone from my home area, home state. After graduating from Adams State College in Alamosa, Judge Lucero went on to receive his law degree from George Washington University Law School, and then he returned to Colorado to clerk for Federal District Court Judge William E. Doyle. Judge Lucero spent the next 30 years in private practice in Alamosa, where he also served as an adjunct professor at his alma mater, Adams State, while also serving as president of the Colorado Bar Association. I believe in that capacity he was the first Hispanic president of the Colorado Bar Association. President Bill Clinton appointed him to the 10th Circuit Court of Appeals in 1995, making him the first Hispanic judge to sit on the 10th Circuit. In an age when attorney careers have become increasingly transient, Judge Lucero's longtime commitment to the communities he has served distinguishes him from lawyers and jurists, and as you can see in your program, has earned him numerous awards and recognitions. Among the many, we have claimed him as our own by bestowing on him an honorary membership in the Colorado Law's Order of the Coif. Judge Lucero will be speaking on a constitutional call to arms and reflections on a judicial career. At a time when constitutional law is part of our nation's daily conversation, this is a topic of great relevance. As you'll hear more about in a moment, Judge Lucero has written significant opinions in a number of cases involving consequential constitutional issues, and we are very, very proud to welcome him to Colorado Law. Let me just add before you start, the applause there jumped, sort of jumped the gun there a little bit. I wanted to say in welcoming that this is also a special year for Colorado Law, because we are also welcoming to our law community Professor Suzette Melville, who's the provost professor of civil rights law. Before joining us, Professor Melville was at Catholic University. She has joined us to not only be another strong member of our faculty in scholarship and research and other service, but also to direct the Byron White Center that I talked about before. And I wanted to also add that at the end of Judge Lucero's remarks, Professor Melville will be engaging in a conversation with Judge Lucero, and also a conversation that will involve videos of students who have been taped with their questions, and also will interact with the audience. So with that, let's welcome once again to the podium Judge Lucero.
Thank you. Thank you so much, Dean. Thank you very much, Dean. I appreciate that introduction. I sat with our colleague Monroe McKay of Utah yesterday, and a lawyer in an appellate argument was being quite solicitous of the panel, kept flattering me, and then he would flatter Judge Matheson, and then he flattered Judge McKay, to which Judge McKay, who's quite ready at the quip, said, I don't mind sniffing at flattery, but I don't drink it. So, but I am so grateful to the University of Colorado Law School for giving me this opportunity and this honor to address the John Paul Stevens Lecture this year. I thank Suzette Melville, who I was able to get introduced around at the 10th Circuit Conference recently. And I thank the Hispanic Bar Association, the LGBT Bar Association for co-sponsoring this event. And of course, how could I not thank the person who's been my sidekick all these years, my wife Dorothy. If you're around here somewhere, right there you are. And Dorothy's been with me through thick and thin, through many of the stories of the reflection of this political and historical and legal and just about every crazy career, as you would expect that anybody who's lucky enough to have lived a full exposure to life in Colorado could have, and I'm very grateful for that. I want to acknowledge the presence of our chief judge in the circuit, Judge Timkovich, who has been introduced. Tim and I are good friends. I can't believe that he'd be on a busman's holiday coming to the talk this evening, but thank you, Tim, for being here as well. I knew Justice White pretty well. I met him in 1959. Maybe it was the fall of 59, the early 60, during the time that he was working as the head of Citizens for Kennedy, running when President John Kennedy was running for the White House. So you see, I really am a pterodactyl. Over the years, we would see each other with some frequency, and after I went on the court, because we shared a common love of fly fishing, we would spend a little bit of time each year when he was off in southern Colorado on the Rio Grande fishing, and I was as well. Let me say about Justice White. He was a modest guy, and he had very little to be modest about, as you know. But he said to me one time that when he got a call from President Kennedy to be appointed to the U.S. Supreme Court, he said, "Why on earth are you doing that?" He just was so modest. This is a case of the office seeking the man instead of the man seeking the office. I didn't know Justice Stevens very well. I met him after I came on the court, but I wanted to acknowledge his contribution to American jurisprudence in a series of cases. He was the lead author on Chevron, a case in which the court held that we should defer to an agency's reasonable construction of ambiguous statutory language. That basically was based on the old theory that the reason for administrative agencies and for independent regulatory commissions was their special expertise that they brought to regulation in the field. He authored Clinton v. City of New York that struck down the line item veto, Hamadan versus Rumsfeld, which held that military commissions established by the Guantanamo Bay detainees were unlawful. And then he wrote notable dissents. Justice Seth Montgomery of the New Mexico Supreme Court, when I was first appointed to the circuit, we saw each other at lunch in Santa Fe, and he said, "Carlos, send me your dissents." And I said, "Well, why do you want to see the dissents? That's what the law is not." And he said, no, I want your dissents because that's really your soul. That's who you are. That's not who your colleagues are. Because as you know, we've got to have three of us before we can decide anything. Unlike the real power of the federal system, the U.S. district judges, they just takes one guy, and they just decide whatever they want. And if they're in a hearty mood, they'll decide they're going to apply it to the whole country. More on that in a minute. So in any event, Stevens authored the case of Texas versus Johnson, in which he somewhat enigmatically said that the majority was wrong and that bans on flag burning were permissible. Clearly, he was talking about his service as a veteran in World War II and his great commitment to the principles of American liberty and freedom. I'm not quite sure that that's the way you express them, but that was his view. Bush v. Gore, he authored that dissent saying that it's the nation's confidence in the judge as an impartial guardian of the rule of law that had suffered. Citizens United, in which he argued that the majority opinion rejected, quote, the common sense of the American people who have recognized a need to prevent corporations from undermining self-government since the founding. And I think one of the nicest things said about him was Cliff Sloan, writing in The Greatest Justice, he said, Justice Stevens has steadfastly thought to enforce the rule of law even when the presidency hangs in the balance. No other justice has a comparable record of leadership in vigorously enforcing the rule of law against presidents in both parties. The talk today, I would like to focus on three things. One, the spirit of the American Constitution, basically the 9th and 10th Amendments, which are almost never mentioned and almost always ignored. B, our oath to support and defend the Constitution of the United States and what that means. C, challenges to the present contemporary society, to present constitutional norms and standards, and then finish off with a comparison to what happened in the Weimar Republic of Germany prior to the rise of Nazism and through the rise of Nazism. So to the first topic first, because I want you to get a sense of the American Constitution as I see it. Virginia, the state of Virginia, played a major role in the eventual adoption of a Bill of Rights. George Mason of Virginia had written the Bill of Rights to propose to the Constitutional Convention and had pretty well relied on the Virginia Bill of Rights to that effect. That was very controversial about whether we should have a Bill of Rights in the U.S. Constitution. George Mason of Virginia actually wrote a declaration, and that was voted down unanimously. So that goes to say this is not a fait accompli or a decision that had been made readily, that we were just going to have a Bill of Rights. And the reason for that, that is that Alexander Hamilton and others had argued that a Bill of Rights, quote, are not only unnecessary in the proposed Constitution, but would even be dangerous. Why declare things that should not be done when you don't have the power to prevent their doing so? That was his argument. James Erdell warned the North Carolina Ratifying Convention that, quote, it would be not only useless but dangerous to enumerate a number of rights which are not intended to be given up. Such a list could readily be misunderstood to mean that any right not listed was no longer or never was a right. And the fear that the Bill of Rights might actually endanger rights, according to Gordon, who has written a book, Getting to the Bottom of the Ninth Amendment, argued that a Bill of Rights might actually endanger rights was premised on the concern that a written list of rights might be misinterpreted to mean that only the listed rights were to enjoy constitutional protection. Does that sound a bit familiar? Today, jurists, Justice Scalia and others, essentially advanced a more, I will call it, rigid view of the Bill of Rights, and essentially arguing that, and this is in the vernacular, of course, that if it's not there, it was never meant to be there. That's just totally contrary to the debates that were going on and to Hamilton's concern that that is precisely what would happen. And guess what? It has. Madison wrote the original text of the Ninth Amendment, and that was ultimately modified by the Select Committee of the House that eventually changed the language to what it is now, and that is as follows. It's very short, as you know. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So, being a fan of originalism and textualism, as many of us are, and I'll join the parade here, I had one of my clerks pull the definition of disparage in 1792's Samuel Johnson's dictionary. And it is defined as, quote, to injure by comparison with something of less value. So the concern was that the rights retained by the people should not be treated as inferior to those identified in the Bill of Rights. The 10th Amendment, which is often cited as a federalism amendment, provides that the powers, the other word, Ninth speaks to the rights. The 10th Amendment speaks to the powers. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So note that even though the 10th Amendment is often cited for its textual commitment to federalism, and the first portion of that amendment does indeed speak to the retained powers for the states, people who cite it too often ignore the second clause of that amendment, which is also or to the people. And that reinforces the core principle that we Americans really and truly are a free people. Plus, consider this. The 14th Amendment, that's adopted after the Civil War, as you all know. And here, the 14th Amendment extends to the states all the prohibitions and restrictions that are contained previously, that were limited previously to the federal Constitution. That, of course, prohibits the denial of to any citizen of the United States, quote, subject to the jurisdiction thereof, the protections of the due process clause and the equal protection clauses of the Constitution. Scholars have long debated the meaning of these amendments. During his confirmation hearings, Robert Bork infamously referred to the Ninth Amendment as an, quote, ink block, end quote, defying judicial construction. Some argue that the amendment is nothing more than a refutation in the argument that concerned Madison, that inclusion of a Bill of Rights could be misinterpreted as expanding the scope of the federal government's power. Others have argued that the Ninth Amendment is a recognition that we enjoy certain natural rights. And my former colleague, who's a judge in the 10th Circuit and went on to be a professor at Stanford Law School, he has argued that the Ninth Amendment does recognize natural rights, but that it is for, quote, the representatives of the people rather than the members of the judiciary to make the ultimate determination of when natural rights should yield to the peace, safety, and happiness of society. I'm not going to opine about the proper role of judges in interpreting the Ninth and 10th Amendments. Those cases keep coming to us, but I do wish to underscore a point implicit in Professor McConnell's view, that we the people, and especially those of us who become attorneys, have a duty to help define the scope and extent of those constitutional rights. We do it through litigation, we do it through appropriate means of lobbying or whatever it is that is properly before a lawyer as an obligation. Well, that brings me to the second point, and that is the oath that we take, and the oath that you as lawyers take, and the oath that you as students will be taking. The oath comes from Article 6, Section 3. It's an interesting place for the oath. That is the supremacy clause of the U.S. Constitution that makes the federal law the supreme law of the land, and it requires all members of Congress, the U.S. Congress, to issue this oath, to swear to this oath. But it also requires, interestingly, all state officials, the state legislature and state officials, executive and judicial, to swear to support and defend the Constitution of the United States as their first obligation. The question I address to you is, what is the role of the oath that you take? What is the meaning of the oath that you take as lawyers and will take when you become lawyers to support and defend the Constitution of the United States? In addition to the oath itself, an attorney, as an officer of the state, and therefore subject to the requirements of Clause 3, is to not only take that oath, but your oath as an attorney goes further. You swear, quote, to employ only such means as are consistent with truth and honor, to treat all those who you encounter with fairness, courtesy, respect, and, again, honesty, and to use your knowledge of the law for the betterment of society and the improvement of the legal system. That's a quote. That comes from the Colorado obligation that you take as lawyers. Our Constitution today faces challenges that are greater than any I've seen in my lifetime, that is, in my career as a lawyer and in my career as a federal judge. I'm not going to go into those contemporary issues. You know them all. You read the press. You're on top of them. But the question is, as we hear daily news reports of attacks on the judiciary, the free press, challenges to the integrity of our law enforcement institutions, and et cetera, what is a lawyer to do? You as lawyers of the next generation are going to face those challenges that my generation did not. For example, should the First Amendment function, how should the First Amendment function at a time when foreign misinformation campaigns flood social media? In United States versus Alvarez, the court held that there is no exception from First Amendment protection for false statements. Absent from those few examples and categories where the law allows content-based regulation of speech, said the majority, Justice Kennedy speaking, some false statements are inevitable if there is to be an open and vigorous expression of views in public and private conversation. Justice Breyer took a somewhat different view in the seriatim opinion, and he said that the courts must provide breathing room for more valuable speech by reducing an honest speaker's fear that he might accidentally incur liability for speaking. So it's clear that the court was trying to protect our rights as citizens under the First Amendment, but what happens when the misinformation becomes deliberate and maybe even paid for? Newspapers, as you know, have struggled financially. Madison was of the view that the newspapers had to play a preeminent role in American democratic society, and Thomas Jefferson wrote that if it were left to him, well, the quote is, "Were it left to me to decide whether we should have a government without newspapers or newspapers without a government, I would not hesitate a moment to prefer the latter." So I suggest to you that lawyers have a duty to correct the record, if it's, as it says in your oath, to employ only such means as are consistent with truth and honor. And when a lawyer enters into public service, the oath doesn't go away, it remains there. Your legal knowledge as students and your careful study of the Constitution will leave you uniquely suited to protect those rights that are, quote, reserved to the people. There are other challenges, of course, going on, and it's really quite surprising to me how many of these have not been addressed by the courts, and the lawyer's role, of course, in presenting these arguments and presenting these views and trying to correct the record on truth and fact is imperative. Newspapers have long recognized, I recognize this from my days as an editor of a college newspaper, that there is a difference between opinion and fact. And journalism students are taught religiously to put the opinion in the editorial pages and the facts in the front pages. Of course, those kind of distinctions are blurring with MSNBC, Fox, CNN, everybody expressing their views on a given point at any given time, where it's almost impossible to blur, almost to distinguish the differences between fact and fiction. Lawyers can play an important role in that, to the extent that they are called upon at any given time to address questions of truth versus misinformation. Back in the early 1970s, Dorothy and I were living in Alamosa, as the dean has said, and we were being integrated into the community. We wanted to host a group of Rotary fellows, visiting one group from England one year and one group from Austria the next. And so we were walking along the banks of the Rio Grande, and this Austrian Rotary fellow, says to me, how long do you think that you Americans will be able to preserve a democracy? I thought it rather a naive question because of our well-inculcated views of liberty, freedom in our form of government. And I so told him. He said, no, I don't mean that. He says, of course you believe all those principles. The German people did too, but they lost it. And it seems to me that you could lose it as well. I think Ben Franklin famously had said, you have here a democracy if you can keep it. And so that essentially was the conversation. I never thought much about that conversation until some while later. And that is when we start looking at the erosion of rhetoric and protection of democratic principles, and it seems to me an over-politicization of American society. The excessive rhetoric of the Dems and the excessive rhetoric of the Republicans can be so aggressive sometimes that you wonder what can come of it. But fortunately, as Americans, we have the Constitution as a balance. So I say, whenever push comes to shove, resort to the Constitution. It is a document that has protected and preserved this country for 2 decades, 202 centuries. It has led us through a civil war. The South at the time, of course, was arguing that the reason they were engaging in the Civil War and withdrawing from the North was because they wanted to protect the Constitution. So it's easy to wrap yourself in the Constitution as an excuse for your conduct without really thinking it through. But if we sometimes despair, I think it's a good idea to look at the previous examples in history, and I turn then to the final point of my talk, and that is the Weimar Constitution, the Weimar Republic, and the rise of Nazism. We've seen, and here's probably why the Austrian chap was asking me the question. They had seen a liberal democracy collapse. The Weimar Constitution provided liberal protections to individuals, including the hallmarks of democracy. This is after the First World War, pre-Second World War. Note, it protected freedom of religion, press, expression, assembly, habeas corpus, rights to privacy, and so on. Sound familiar? It's our Bill of Rights. But it had a flaw. Article 48 gave the president broad emergency powers that could be invoked in situations, quote, where public security and order were seriously disturbed or endangered. Though the president needed to be popularly elected, the president could dissolve the Reichstag at will under Article 25, and he could call for new elections, giving the president and the chancellor great powers over the Reichstag. Not uncommon in European democratic models. Otherwise, parliamentary authority was absolute. It included the authority to delegate all powers to the chancellor. It permitted parliamentary abdication. So come February 28, 1933, was the Reichstag Fire. 1 day after the fire, the government of Germany suspended crucial civil liberties in response to the fire, generally considered to have been carried out by the Nazis for the purpose of restricting civil liberties and imprisoning political adversaries. They suspended the right to habeas corpus, suspended the right to freedom of expression, freedom of the press, freedom to assemble, privacy of postal communications. It removed requirements for warrants to search private residences. The Nazis blamed the communists for the fire. They used the fire to justify the imprisonment of communists, the suppression of the communist press, and eventually the imprisonment and suppression of all left-leaning parties. The prior invocation of Article 48 paved the way for broader use, and the Nazis then proceeded to remove certain rights of judicial review. As lawyers, I think that would send a chill up to your spine, although maybe some of us appealing to the 10th Circuit might not be such a bad idea. Some of you might argue. But in any event, here we are. All these rights had been then revoked. Previously, President Hindenburg, President Hindenburg declared a state of emergency in Prussia and then proceeded to do precisely the same there. The German Supreme Court determined that the invocation of Article 48 was subject to judicial review, but accepted the government's finding of a genuine situation of emergency, permitting a temporary subordination of the Prussian government to the national government. And so, history or nature takes its course, and President Hindenburg dies. At that point, the Chancellor, Hitler, uses the opportunity then to consolidate the power of the presidency and of the Chancellor unto himself. There were only two remaining restraints after the Enabling Act. The president could remove the Chancellor. He was dead, no chance. And the Enabling Act would have to be extended after 4 years and then 2 years thereafter. But this was a pure formality with the elimination of all non-Nazi or Nazi-aligned parties. And here's the part that I thought that we as lawyers should reflect on. As of August 14, 1919, judges in Germany took this oath, quote, "I swear loyalty to the Constitution, obedience to the law, and conscientious fulfillment of the duties of my office, so help me God." Our oath is, "I swear to support and defend the Constitution of the United States, against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this oath freely, without reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office in which I am about to enter." Not totally unlike the oath that the German jurists were taking. Lawyers swore to that same oath. Yeah, the Reichstag Fire, as of August 20, 1934, the oath has been changed. This is now the oath. Quote, "I swear I will be true and obedient to the Führer of the German Reich and the people, Adolf Hitler, observe the law and conscientiously fulfill the duties of my office, so help me God." So we come back to our conversation with the Austrian fellow and suggest, with the benefit of a little bit more reflection, now having practiced law or additional amount of time and now having been on the bench, what is the primary difference between us and them? What is the pivot point in the American model of democracy that prevents, hopefully will forbid and ever prevent this from happening to us, and that is that we have a constitution that was not passed by statute. We have a constitution that enshrines not only the rights, but that incorporates through the Ninth Amendment what I consider in many ways to be the soul and the spirit of the Declaration of Independence. That is to say that we are endowed by our Creator with certain inalienable rights: life, liberty, and the pursuit of happiness. So, yes, it's very difficult to define unenumerated rights. Courts have expressed them in a couple of notable cases, and it is difficult for us as citizens to protect those unenumerated rights. But if we are to be a free and independent people, to be the home of the free and the land of the free and the home of the brave, it is going to take us as lawyers, and you, particularly the students who will be forthcoming, to study the depth of these rights, to litigate when necessary, to protect those rights, to speak as citizens in the protection of those rights, and to be aware. And to be aware when the citizenry deviates from those norms. Lock her up. Lock her up. Lock her up. Those kind of chants are very worrying. Not because they are addressed at the D's or that they can be addressed at the R's, but because they threaten us, all of us, the A's, the Americans, with the dilution of our constitutional rights and privileges. And that is my call to arms, to stand up as lawyers and for us to stand up as judges to make sure that the Constitution of this republic, of this great country, continues not just for another couple of 100 years in the grand experiment of democracy, but indefinitely into the future, because that is what makes America the shining star. Thank you very much. Appreciate your time.
Thank you so much.
I hope I didn't run over.
You did.
Too
It's okay. We might run a little over. That's okay. I so appreciate your remarks today, and it's such a pleasure to have gotten to know you at the 10th Circuit Bench and Bar Conference, and Dorothy as well. We were all sort of brainstorming a little bit that day about the kind of conversation we might have, and so it's exciting to be here and to be directing the Byron White Center. So in terms of format, I'll sort of kick it off and take prerogative, and then we're doing something a little different where the students have videotaped questions in advance. We'll be showing those videotapes. So I'm grateful to the judge for inviting student leaders to participate in this way. This is a first for us, so we'll see how it goes. But let me just start here. I heard you talk a little bit about originalism and that you're a fan. Well, it
was a bit tongue-in-cheek.
Okay,
but no, but I am. I think textualism is important. I mean, you have to follow the text, but you also have to recognize that you can't use the Constitution as a straitjacket to define the rights of citizens in an evolving society.
Right. And I appreciate that, because I think we have this battle, this sort of normal tension between the originalists and those who see the Constitution as more of a living document. And hearing you talk about what is the obligation of lawyers and judges to support and defend the Constitution. What do we mean by the Constitution? Do we mean the Constitution in 1789? Do we mean something that is changing and evolving over time? Certainly, and this may be on a lot of people's minds, it's on mine. Having watched the hearings all day, the Senate confirmation hearings, we see that things like sexual harassment and sexual assault are a relevant part of that conversation, right? And so we have this evolution in terms of what we think is appropriate to be raising and expecting from judges. So I know you probably can't touch on certain details, but I would love to hear your thoughts a little bit about that process. What do we mean when we hold people accountable today, judges, to support and defend the Constitution? And what the process and what are the criteria for judges today? What should they be, given what we're sort of seeing, the hearings, the Senate confirmation hearings today, which are very disturbing?
Well, the judiciary has been defined historically and was by the founders as the weakest branch. We don't go out and seek out cases. We don't give a speech and then say it's so ordered. I mean, we have all kinds of limitations on our standing in jurisprudence. We have to have controversies, as you know, that are ripe, that they're justiciable, that they are available, that are susceptible to actual remedies that the court can issue. And for that reason, of course, I don't think you could find a federal judge in America who would express a view on what constitutes due process under the legislative branch of government. You would hope that all three branches respect due process, but query, would we even have jurisdiction to entertain the question of whether a committee of Congress or the Congress itself is appropriately delivering legislative due process? Mm-hmm. I think the courts would probably say, and it's nice having a colleague here, but he'd have to agree with me before it'd have any teeth, right? I think the courts would probably say that the question should not be reached under the political question doctrine. And the political question doctrine provides that if an issue is political in nature, susceptible by cured by the legislative branch, that we should go hands off.
Mm-hmm. Mm-hmm. Thank you. I'd like to turn to our first student question. We have Leah Fugere, who's the president of the Christian Legal Society. Let's hear from her.
When a right of one person directly interacts and interferes with the right of another. My name is Leah Fugere. I'm a 2L here at Colorado Law, and I'm the deputy director of the Acequia Assistance Project, as well as
I've been a bit of a trouble hearing.
All right, can we
Thank
turn
you
it
for
up?
being here, Judge.
Okay.
Would you mind running that again with the increased volume,
Can
please?
we turn it up? We can't hear. Thanks, John.
My name is Leah Fugere. I'm a 2L here at Colorado Law, and I'm the deputy director of the Acequia Assistance Project, as well as the president of the Christian Legal Society. Thank you for being here, Judge. My question for you is, in one of the most talked about decisions of this past term, Masterpiece Cake Shop largely seemed to sidestep the substantive issue. That is, what happens when a right of one person directly interacts and interferes with the right of another. It seems that the sidestepping largely is the Supreme Court tacitly expressing a preference for the states to decide the issue. Can you comment on whether or not you think there's a preference for that? And if and when you believe that the substance will again go to the Supreme Court, how do you think that this court will come out? Thank you.
Okay.
Thank you for the question. I think precisely because of her last point, when will this come up again, that I must tread very lightly.
Right. Mm-hmm. I understand.
People are entitled when they come to a court, and the first element of due process is to a fair and impartial arbiter. And so if I go around expressing my opinions and then even worse, advocating them within society, I could hardly be in a position to turn around and rule otherwise. So I'm really super cautious about that. No question. That court has invited litigation on the point that our student raises. The court has essentially basically set forth some standards on which they're going to apply the next time the case comes up, and you can bet your bottom dollar that if it doesn't come before the 10th Circuit, it's going to come up before one of the other circuits. The principles, I think, were well articulated by the court in the case, and I think we'll leave it at that.
Okay,
Right.
all right, fair enough. You talked about challenges to constitutional norms today, and I'm wondering, how do you, I can name many that come to mind in terms of immigration or criminal justice or access to the courts, but it seems, how do you identify what are the challenges to the constitutional norms and where's the line? And so what I'm thinking is, certainly changes can be incremental.
Right.
And they can be so incremental that they go under the radar before it's too late.
Right.
One of the things that I look at is civil procedure and the ways that the court, in my opinion, diminishes access to justice, whether it's a heightened pleading standard or it's class actions not being as readily available or deference to arbitration agreements that don't give people access to the court system. Those things sort of fly under the radar. So how do you know when you've arrived at a place? When do lawyers have to act? And there's a constitutional challenge, like the norm has been challenged.
Right.
You get to Germany, Nazi Germany. At what point do lawyers have that obligation to actually act?
Well,
and how do you know?
I think lawyers had to be vigorous in their defense of due process, because if you don't, you're absolutely right. This is the slippery area of the law where you take a shortcut today and a shortcut tomorrow, and pretty soon there is absolutely no process left. If I may do a footnote on the German Republic. In doing the research for my talk, it turns out that 20% of the lawyers at the time of the Reichstag Fire in Germany, 20% were Jewish. 50% of the lawyers in Berlin were Jewish. Within a few years, those lawyers had been delicensed, disbarred, and there was nobody to speak up. So that's a footnote to what I said before. Lawyers, what did Shakespeare say? The first in the first thing, if I want to take over and do bad things, the first thing I do is kill all the lawyers. So a lawyer who's sound asleep might as well be dead in Shakespearean terms, right? Because they're not standing up for the right thing. A couple of points that I think I can address, and Tim has heard me speak to this before. I get troubled when administrative agencies and independent regulatory commissions that were passed by Congress, challenged before the U.S. Supreme Court, declared constitutional, have a penumbra of jurisprudence around them. Humphrey's Executor, Meyer v. U.S., those series of cases that talked both about the constitutionality of the administrative agencies and the independence of the agencies. All of that's been vetted constitutionally. We have administrative agencies in this country. And all of a sudden, you get society, the hidden government, then it's the dark government, and then it's all these sinister descriptions of democratic institutions. Right. I think that Justice Gorsuch, in one of the cases last year, some of his first writings on the court, were saying that the question of the continued validity of Chevron, if I'm quoting him correctly, is we leave that for another day. Leave that for another day? That was decided 80 years ago. I mean, what do you mean another day? The question really is the question of whether we are going to set aside precedent that has been established for 70, 80 years will be revisited another day. I think that's a fairer way of stating that proposition. My only contribution to that debate would be one that I raised at the Constitutional Center in Philadelphia last year, and that is, what alternatives do you propose? There are hundreds of thousands of adjudications that are done by the Social Security Administration each year. And do you propose to dump those on Article 3 judges? I mean, Judge Timkovich and I and our colleagues are supposed to now start handling hundreds of thousands of administrative law cases? I don't think so. I just think that if we're going to have a vigorous debate on those kinds of issues, I think the proper place to have those debates is not at the U.S. Supreme Court. It's not in the circuit courts. It's in the legislative branch. So that if they need to revisit those agencies, fine. And that's their power.
I think that brings us to a good question that's posed by Nick Monk, who's the president of the SBA. So if we could hear from Nick.
Hello, my name is Nicholas Monk. I'm the president of the Student Bar Association at the University of Colorado Law School. My question for Judge Lucero is, in light of today's highly partisan environment, what role should the judiciary play in policymaking instead of simply deciding on the legality of government actions? In the era of the travel ban, emoluments clause challenges, and presidential reductions to public lands, can judges honestly say that they are not themselves making the law?
Okay.
Wow.
Hello.
I think it's what a timely question. Erin Chemerinsky had invited me to judge a moot court competition at the University of North Carolina. No, at Duke. He was not at Chapel Hill. He was at Duke. At Duke when he was the dean there, and so I went there. And the other two members of the panel were another circuit judge and a third circuit judge named Sotomayor. And so they asked us, hey, what's the difference between a district court judge and a circuit court judge in terms of your jurisdiction and authority? And we started talking about policy and how the circuit courts maybe sometimes edge up against forming policy, I say to my dear student, without kind of asserting that they do. Because that's not our role to make policy. We just have to decide what the law is. Unfortunately, the policies many times intermingled with the law, and it's pretty hard to disentangle those nuances. But so she proceeded to express an opinion, which is, I think, fairly infamous now, because they ran it during her confirmation hearings like they looped it. that moot court, that student discussion at the University of Colorado. You don't have to worry about me. I'm 77. I'm not going to be on the U.S. Supreme Court. No way, no how. They don't appoint pterodactyls to the court, so I don't have to worry about that. The rest of the question, wow.
So when we think about policy judges as being accused of making policy, and you and I have talked a little bit about national injunctions, and you know that recently in the Trump versus Hawaii case, Justice Thomas spoke critically of national injunctions and actually took exception to an article that I had written in the opposite direction. And so I'm wondering if you can speak a little to your thoughts of to what extent you think, as the Attorney General Jeff Sessions has said, this is judicial activism. Others have said this is a very important check and balance on executive power. Do you have a sense of that in terms of what's going on?
Well, and your first point being what again, please?
Just the tension, the tension between, does it look like?
But I thought you were talking about the national injunctions.
National injunctions, does that look like judicial activism, or is that an important check and balance on executive power?
It's a question that, interestingly, is up before the House of Representatives. They have just, was it about a week ago that Congress just up and popped up a law, a series of bills in the waning days of Congress. One is to split the Fifth Circuit into 4 divisions and add 5 judges, which some people have criticized as being, quote, court packing. The other is to address precisely the question, reducing the jurisdiction of U.S. district judges from prohibiting them from issuing nationwide injunctions. And no doubt that question will be coming to us as well. And so I won't express an opinion on that, but that is essentially I don't think it's an arbitrary and capricious act on the part of the court, so much as probably trying to place their imprint on a current constitutional question that they think needs to be answered, and that the country would be better off if we did. The problem is that let's look at it as a practical matter. Let's say the Sixth Circuit does that in Cincinnati. Some U.S. district judge in Cincinnati applies a nationwide rule. Now it's going to be appealed and it goes to the Sixth Circuit. It has an impact on you in the 10th. It has an impact on people in California in the 9th. It has an impact on people in New Hampshire on the 1st. Those circuits are kind of cut out of the process, and it really kind of goes to the 6th. So it does kind of muddle the process, but the Congress of the United States does have the power to define the jurisdiction of the federal courts. And you probably have seen opinions where we always start saying we have jurisdiction, because unlike the state trial judges who have plenary power to issue anything, rulings on anything that comes before them within their subject matter jurisdiction, we don't have that kind of power. We are limited to the jurisdiction that is granted by Congress. And so let's stay tuned. Let's see what they would do. I mean, that's the political process. I won't speculate.
Okay. One last student question, and then we're going to open it up to the floor. So let's hear from our last student leader. This is the editor-in-chief of the Law Review, Hannah Regan-Smith.
My name is Hannah Regan-Smith. I am a third-year student at CU Law and the editor-in-chief of the Law Review. My question for Judge Lucero is whether you have a theory or philosophy of interpretation. If you do, I'd be curious to hear more about how you developed your theory or philosophy. In particular, at what point did you start to feel that you had a coherent approach to interpretation? What were some of the factors that influenced your theory of interpretation, and how has that theory changed over time? Thanks.
Thanks. Okay. When I was a law student at George Washington University in D.C., I was a classmate with Harry Reid, who was then a student from Nevada. And so we would share cab rides after class in the morning, and in the early afternoon, we'd share a cab ride. He would go work at the Capitol Police, and then I would work at the Senate Judiciary Subcommittee as a low-paid staffer. That was fun, but it did this. It kind of had me in early on in the legislative process federally, because we were working on the revisions to the Federal Administrative Procedure Act, to the Freedom of Information Act, and any number of other kind of housekeeping legislation on the Administrative Practice and Procedure Subcommittee. From that, I learned a little bit about how the laws are written at the policy level, because we'd have the American Society of Newspaper Editors, the Sigma Delta Chi, I think, Freedom of the Press group out of the University of Missouri. Any number of people would lobby the inclusion of language in the act. Then you would have the federal appellate, the federal agencies that would be impacted by the legislation, and they would come in and they would lobby as well. they'd lobby both at the hearings, but they would also lobby a little bit before the hearings. And the process then led to kind of how I think you've heard it referred to as making sausage. It isn't totally that. I mean, I think the substantive committees of the Congress really do know their business, and they really do pay a lot of attention to the precise words of statutes. But a lot of times, and that's also an occurrence, is that legislation will come written by somebody else. It may be written by a trade organization. It may be written by a law firm that's lobbying for some particular clause that they want in legislation that'll help their client. And those various sources then really are the source of the words of the acts that your student is asking about. So when I first started practicing, I would pay, I think, a little bit more attention to the legislative history because of that kind of respect that I got for the process. But as I proceed and as I practice, and then after I went on the bench, I think you have to be stuck as a court and as lawyers with the language that appears in the statute. And that's what I think led Justice Kagan to say, today we're all textualists. It's because I think that whether it's the legacy of Justice Scalia or whether it was the old rules, we follow the text first, and then only if there's an ambiguity do you resort to legislative history and caveat as to that legislative history, because you don't know where it's coming from.
Yeah, thank you. Let's open it up to the floor for, I know there are a lot of people here. We have a great turnout in terms of lawyers and students and judges and professors. So there's a mic that's going around. If we could have, the mic will come to you. So if you have a question, then please go ahead, raise your hand, and we'll get a mic to you.
Well, while that is happening, may I say, Professor Melville, that I very much appreciate the way you handled the student questions and gave students an opportunity to ask these questions. I think it's really super.
Good, great,
really
thank you.
Great,
Okay,
creative
so that
way to present them.
Tried something new this year. Okay, so let's go ahead and have questions from the audience.
Hi, and thanks for coming and speaking to us tonight. I don't come as a student or a judge. I come as a regular old citizen, and I have two questions for you, and one of them is going to probably make you uncomfortable, and I apologize for that, but I really have to ask it at this point. I would like to know your viewpoint on pro se litigants. So I understand what you're saying, and in the context of oaths, I'm not sure if you're aware of what's going on with the paper terrorists and the fact that they uncovered that judges don't have oaths on file and law enforcement has had their oaths falsified.
Oh my goodness.
Yeah, so I really appreciate that you addressed the concept of oaths and how you believe as a judge that plays in and how it could take us to where we don't want to be. I realize it sounds like you're a practicing judge, and that may be a difficult question. It's an important question.
No, that's quite all right. That's quite all right.
Because we've got people in prison now and more going that were sentenced to close to 40 years. Okay?
Right.
And I've sat in the hearings for the next one that's going to go, and he's representing himself pro se. So these are really hard and important questions, and I've tried to talk to some of the judges that I know that are abusing the law, and they, of course, don't want to talk to me. So we need to have a real discussion as citizens, judges, and prosecutors regarding the fact that the oaths are not on file and that you guys are not owning up to that law enforcement requested staff falsify law enforcement oaths, and staff did, and then reported it to the paper. Okay, so if there's anything you can address on that, and then as well as the fact that as judges and prosecutors, you have run amok from the perspective of pro se litigants, and I understand that you're saying you're using the term textualists and that you're following the statutes. Well, the statutes are screwed up, as we know. Everybody knows it, particularly pro se litigants, particularly this one. And how do we get back to some semblance of sanity, and prosecutors and judges who don't have oaths on file, who are violating the law and getting away with it?
Well, I'm proud to tell you that we have a process in the federal system of habeas review by the courts, the federal courts, where we have limited jurisdiction to review the actions of state courts. But one of those areas is the area of habeas review. And there are all kinds I won't bother you with the mumbo jumbo of the statutes like EDPA that preclude our jurisdiction somewhat. But for the most part, a litigant, no matter how wealthy, no matter how poor, no matter how well represented, no matter whether she's unrepresented, have access to the courts in that area of the law. And you would be surprised how seriously each one of us as judges considers each and every single habeas application that comes before us. Some are in handwriting. Some are on just a plain old sheet of notebook paper. Others are done a little better. Some are done by jailhouse lawyers. But whatever, every single case that comes before us is going to be considered seriously, taken seriously, considered respectfully, and ruled upon under the applicable law. There's a principle of judicial procedure in these cases that if a person is pro se and is not able to write as effectively or as eloquently, as articulately as the next person, as the next lawyer, that we are going to interpret the document as well we can to afford the basic rights to that litigant. Now, as far as the others, I mean, our oaths are, not only are they in writing, they are totally of record. I mean, there's no question about federal judges on oaths. I don't know anything about the state municipal judges or other lesser courts, but I'm satisfied that the typical district judge and county judge, municipal judge in Colorado surely must have those oaths of record. But if they don't, well, there's access to the courts to adjudicate those things.
So I'm sorry, in terms of the interest of time, we're going to take one question, and then just remind people we have a reception afterwards, so you can also pose questions and have conversation with the judge at that time. So can we take, we have one in the back? Right. Okay, thank you.
Hi, Justice Lucero. Thanks a lot for the presentation. I'm here as a student, actually a pre-law student. You talked today about the politicization of, everything going on and the attacks on our democratic institutions. And I was just wondering if you had any thoughts on whether those institutions can be defended purely in the courts, or whether you think, especially given that politicization even of the courts and the nomination process, whether there has to be more focus on political change to defend those institutions.
Well, it's as frustrating for us as it is for the average citizen to see the developments of the political process, but it's healthy. I mean, that's just the way the American democracy is created, to afford everybody their basic rights to speak and sometimes to speak not very nicely and not very civilly. What I was saying here tonight is I'd like to see lawyers, as they consider their oath, to speak only the truth and to speak with integrity and honesty, to not participate in anything that would smack of dishonesty. And when they go into the public sector, they are still kind of, the oath hasn't worn off, as Judge Connor used to say down at the Valley. So beyond that, let me make this remark, that I think it's a little disturbing, I think I can say this fairly, to see the development of what is going on at the Supreme Court appointment level. I agree with you in this regard. We're seeing advertising. You are seeing negative ads now attacking a nominee. You're seeing the pro ads. Pretty soon, I think the public is going to say, what's the difference between a race for the presidency, for the Senate, for the House, and a U.S. Supreme Court nominee? It didn't used to be that way. When Byron White went on the court, when Justice White went on the court, when Justice Stevens went on the court, when Justice Souter went on the court, you name them, that didn't happen. And that's why I opened my comments with Justice White. I mean, he said, what, me? I mean, the office basically seeking the person instead of the person seeking the office. I think it would be a real mistake to slip out of that paradigm and move the court into the process. But the rest of it, I'm a private citizen just like you, and I can observe and listen to TV, but we're powerless. We don't have a thing to do with that. We could just observe it as entertainment, basically. And I wonder sometimes whether the American public isn't doing the same, looking at it as entertainment. But I think we had one other question that we should take if we can.
Okay.
Yeah.
Do we
Just
have the
because,
mic?
yeah, she was so patient here waiting. Thank you.
And I'm sorry we are short on time. We're going to quickly move to the reception and open up the floor.
I think perhaps you may have just addressed it. With your call to arms for attorneys, I think about Korematsu. I think about all of the court opinions during the HUAC era. They don't offer me any comfort whatsoever. Right. So what do you think that we as attorneys might be able to accomplish with a call to arms?
That case has become infamous, right? Fortunately, I think the American public came into stark shock about the consequences of that case. Governor from Antonito, yes, Ralph Carr. It's a good thing he's not alive. I forgot it. We're both from Antonito, and I forgot his name. But in any event, he was a lawyer, and he went to great lengths to say that even though the federal government was going to engage in this kind of behavior, he was not. And so society has lionized him and made a hero of him, and basically has condemned the actions. It was not the Reichstag fire, but for them, for the Japanese, it was pretty close. Lawyers' obligation is to be more vigorous residents in your society, take a more active part. I don't want to tell stories out of school because everybody's going to jump and take my question from me. People say, how do you get such great law clerks? And I have a secret question that I ask in the applicants when they come in. I'll let you in on the secret. I say to them after we finish the interview, I said, what would you hit the streets and fight for? I don't mean throw bricks, but act like a responsible U.S. citizen and either protest or advocate. And that's when I get to the heart of who that kid is. They will tell me some will fight for educational equality. Some tell me that they will fight for effective health care. Others will tell me that they really feel strongly that, and this is before my decision in Kitchen versus Herbert. They're not kind of pandering. They're saying, if there was discrimination against gays, if there was discrimination on the basis of race, count me in. I'm standing up and speaking up. I wish I could give you magic formulas, but as citizens and as lawyers, first and foremost as lawyers, I think you have the obligation to lead society, to try to create an atmosphere and a spirit of true democracy.
Well, we'll leave it on.
I hope that's not just platitudes.
We'll leave it on that. We get a lot of CU grads, by the way, as his clerks, so we're very proud of that. Well, we'll leave it with that. We so appreciate your talk and your remarks and your reflections at this very important time. So if you could join me in thanking Judge Lucero at this time. I also would like to thank our sponsors. We're really excited and privileged to have done this with you. And so we are doing this through the Byron White Center for Constitutional Law, but we also have the Colorado LGBT Bar Association and the Colorado Hispanic Bar Association that has co-sponsored this with us. So we really appreciate your support. We obviously we appreciate the support of the Dean. And those who have helped organize this, Julianne Williams is back there, and Jennifer Sullivan and Hannah, who've worked really hard. The folks who did the IT, they did a great job. So I appreciate that. And just to end on the note, the call to arms, we do have flyers in the back, and it's a flyer, it's a one-pager answering the call. Right? We have a constitutional call to arms, and so we don't want this just to be a lot of talk and conversation. We want people to roll up their sleeves and get involved and take it seriously. What are the steps we can do? What actions can we actually take to live out that oath to the Constitution, to defend and support the Constitution? So that flyer back there gives you all kinds of opportunities, the lawyers and law students, to do pro bono work and to get involved in some of these matters. So please take a flyer. This is just the beginning of the conversation. So thank you so much. We're going to go ahead and have a reception and enjoy Judge Lucero's company. Thank you so much for coming.
Thank you, guys. Yeah.